Hello, good evening, Dr. Ankit. Welcome.
Good evening, Kalpesh ji.
Yes, Mercy. Welcome. So I think it's uh shall we start,
Yes,
Dr.
yes,
Ankit? Yeah, sure. So Ustavi, over to you.
Okay, sir. Am I audible, sir?
yes.
Yes, sir. Good evening, everyone. I invite you all to embark on this transformative journey of professional growth, collaboration, and innovation. Welcome to the first ever 1 month national level online faculty development program on teaching laws in the 21st century, a collaborative effort between Law Teachers India and Gujarat Maritime University, Gandhinagar. Let us embrace the challenges and the opportunities of the 21st century in legal methods, guided by the expertise of Dr. Ankit Awasthi, sir. Sir is currently working as Assistant Professor of Law at HNLU Raipur. He serves as a head of the esteemed Center for WTO and WIPO studies. Additionally, he plays a vital role as the faculty coordinator for the recruitment and the internship coordination committee, demonstrating his commitment to fostering professional growth amongst students. He is the faculty advisor of Kautilya Society at HNLU Raipur, a chapter established under the Vidhi Center of Legal Policies, New Delhi. Moreover, he is the founding member of the Digital at the rate HNLU team, an active member in various other committees within the university, showcasing his dedication to the institution's overall development. He has been the faculty coordinator of Lex Osmosis and Alumni Connect. He teaches international trade law, legal methods, media and law, professional ethics at the undergraduate level, and general principles of corporate law and law and justice in globalizing world at the postgraduate level. His area of research includes institutional reforms in the field of corporate governance. With over a decade of extensive teaching and research experience, he brings a wealth of knowledge and practical insights to his academic pursuits. He was granted the prestigious Shastri Conference and Lecture Series grant for the year 2022 to 2023. I welcome you, sir, on this platform to share your knowledge. Over to you, sir.
Thank you, Subi, for such generous introduction. And before I begin my session, or you could say the conversation, I would like to express my sincere gratitude to Kalpesh ji for, you could say, ushering such a momentous task to, in fact, organize 1 month long faculty development program. So it is not an easy task, especially in the online mode that I do, you could say, understand. That's why this express of gratitude is not just a formality, but I feel so. So without taking a further ado, let me share my screen so that I can begin to discuss. Is it visible?
Yes, sir.
Okay. Yes. So there are three methods primarily we may learn wisdom. First is by reflection, which is the noblest one. Second by imitation, which is the easiest one. And third by the experience, which is the bitterest one, as mentioned by Confucius. And I would like to begin this today's session with this noble thought, because though in our academic journey there are several subjects which we are used to undertake, which we are used to impart. However, when we you would say try to reflect on any of the subject, we always look towards an opportunity, and that's why, as I mentioned, when I received, in fact, one this particular idea has been floated by Kalpesh ji, I was pretty much, you could say, impressed by this one because I have considered this thing as an opportunity to reflect what I understand in the name of a starting point of my career itself. And in the year 2012, when I have undertaken this particular academic profession, at that point of time, apart from legal matter, there were other two more subjects which had been allotted to me. But legal method was somehow different because this subject I taught more than a decade, I could say. And that is one part of the story. Apart from that one, the connect which I have made through legal method with the first year students. In fact, when they have been graduated, still that connect is there. Which I feel that legal method is not just a subject, but this is something which is very much indispensable when we are in the field of academics. So I will begin with, first of all, the structure of the session, which I am going to follow in the given span of time. First of all, I would highlight about the legal method, like from where it came into existence, and I will refer some of the reports or some foreign jurisdictions also in this regard. Then I will highlight about the legal method, what this legal method is all about, and the foundation of the legal method that I will try to establish. Then I will discuss about the draft of the model syllabus. I have mentioned the draft of the model syllabus because obviously from the academic liberty point of view, we all are required to have that much freedom to design the syllabus, and that designing itself supposed to depend on the autonomy which is given to the institution and by a institution to the faculty members. At the same point of time, that is something which is connected with the experience and the accumulated knowledge at a given point of time of that faculty member. That's why, in spite to say a syllabus, I think to mention is a draft of model syllabus, that would be more proper phraseology. Then I will discuss about the suggested pedagogy and the teaching method, and then I will throw some light on the evaluation and the assessment and issues and the challenges in the implementation. And at the last, I will refer some of the important books and important readings. So first of all, when we try to see the exact positioning of legal matter, obviously we have to begin with the Bar Council of India. There are rules on legal education, and in part number 4, we can get about the scheme of different type of subjects which are there. And when we try to see the schemes of subject, there are some subjects which are under the head of the compulsory subjects. There are some subjects which are under the head of optional subjects. There are some subjects which are there in the head of honor subjects. Now, one thing which is important to mention here, that legal method has not got place in any of the subjects in an independent capacity. As I have highlighted here, the first point, that the compulsory subjects in legal education, there the first point or the first entry is of jurisprudence, and within bracket it is mentioned legal method, Indian legal system, and basic theory of law. However, when we see the you could say opening statement which is mentioned there, it gives us liberty to design course in the name of legal method. That's why in some of the universities legal method is there in the first semester primarily. In some universities it's a combination with other subjects. And in that manner, jurisprudence in some universities offer in second semester, in some universities that is in the second year, or in some universities that is the third year. So in that way, there is no uniformity, which I could say in this regard. However, there is one thing which is certain, which I have found, that there are two streams of legal educations, which all of us are aware. One which is known as 5 years integrated course, and second one which is known as 3-year course. So as far as integrated 5-year course is concerned, legal method got place within the prescribed, you could say, syllabus requirements of the curriculum of the 5-year integrated courses. But legal method is not a subject, as per my limited understanding goes, in the 3-year courses. So that is a basic difference when you try to see what the exact placing of the subject that is known as legal method. So what I said is I'm summarizing that when we see the 5-year course, there the legal method is there in the first year, but the legal method is not there in 3-year course. And when we talk about the legal education rules, which are still applicable, that is of 2008, it has place there. At the same point of time, when we take a reference of draft rules of legal education, 2019, then legal method in the same format as mentioned on the slide is present there, which shows that first of all, when we try to see that subjects in the terms of ordering, then the very first subject which we have to undertake is legal method, or from could say faculties to students point of view, if I say, then what the subject which we have to offer at the first point of the introduction, then that is the legal method. Now, when we take a look of the preamble of the draft rules of legal education, there it has been found that it has been a decade of the implementation of 2008 rules. But what has been found by the Bar Council of India, that there is a need to do some changes, or I could say do some reforms, because of the 4 points which have been identified in the preamble of 2019 draft rules, which are rapid global integration of legal regulations for trade, commerce and industries, and technological innovations in global economy, the need for national laws to be more sensitive to the international human rights legal principles, necessity of emphasis on clinical skill training both in the courtroom litigation management and an alternate dispute resolution mechanism for the professional legal education in the interest of speedy delivering justice, and the need for emphasis on super specializations in various branches of law to upgrade the curricula owing to latest developments and achieve optimum efficiency thereby. Now, why I am citing these 4 clauses which are mentioned in the preamble, reason being, until and unless we have not taken a look of the importance of the legal method, I think it would not be clear how far we are going to achieve the objectives which have been enshrined in the draft legal rules. And I think that is a basic difference when we try to compare the 5-year course and the 3-year courses. So apart from that one, if we take a reference of the United States of America, there is a report that is known as McPlatt report. In that one, the education continuum, that concept has been given, and which has facilitated the concept of continuing legal education, which says that it's not all about the education, or it's not only about the clearing various subjects which are there, that could be 30 or that could be 56, but it's all about some of the skills, some of the nuances of the law which are required to be understood and which are required to be upgraded time and again. Reason being, if these skills are not, you could say, integrated with the education which we are going to receive, then the legal system itself is going to be overburdened with the inflow of the graduates. So primarily, these are the reasons why the legal method came into existence. In fact, in Indian scenario, if I say after 80s, when the concept of integrated, you could say 5-year course has started, and it was not very much present. This I could say because I have referred different syllabuses which were there, in fact, before 80s. And I have gone through different committee reports also, but I have not found this legal method in Indian scenario. So that has started with the inception of integrated 5-year course. And I will mention about the importance of the same in my latter part of the discussion. But primarily in this way, the legal method as a subject which we can find out in the rules of legal education. So primarily when we talk about this term, legal method, obviously it is very clear it's a combination of 2 words. First, that is a legal, and second one is a method. From general introductory point of view, I could say that it's something which deals with the methods to understand the law, but that would be one part of the story. Apart from that, some of the writers have described the legal method as a combination of 2 independent subjects, which are legal theory and research methodology. But if you don't follow, you could say, either of the approaches which I have mentioned, and if you try to see only from the legal education point of view, then I think we could begin with the Columbia Law School, where legal method was originally introduced as an independent subject in the year 1944. And it has evolved over a time to reflect the changing nature of the legal profession and the society. In fact, when we try to understand the method, there are time and again, you could say in the foreign jurisdiction, the experiments have been made. And I think I have mentioned somewhere in my slide, but at this point of time, I mentioned that Christopher Columbus Langdell, when he became the dean in the Auburn University School of Law, then he introduced the case law method. At that point of time, it was criticized because there the prime method to teach the law was simply the lecture mode or the monotonous or the one-way communication which was there in practice for a much longer time. So obviously when any new experiment was supposed to be there, it is not supposed to be well received, and the same thing happened there. However, he was very much determined that how we are supposed to come up with different types of methods so that we can make law not only just from the theoretical point of view interesting, but we can also improve the pragmatic aspects in this one. That's why he has written, in fact, a case book also. And the first, you could say, book which was written on the case book was with respect to the contract laws. And that was also pretty obvious because when we talk about the importance of any of the subjects in foreign jurisdiction, then apart from theoretical subjects, something which is more important from practicability point of view, then that was the Contract Act. So that's why the first case book was that, and the method which has been introduced there was the case law method. That worked there, but obviously legal method as a complete, you could say, subject in its own autonomy has not got place. Nevertheless, that has been accepted in the name of method which are required to be applied. That is, it has set a path that there should not be only one method to teach the law or to impart the education in the field of the law, but they are supposed to have different methods. The same point of time, it should not be only one way to understand why we are supposed to educate people in the field of the law. Like it's not always just to make the students as a lawyer, that is the prime objective, but there are different opportunities which are associated. In fact, from the civic responsibility and the civic professionalism point of view, there are n number of options. That's why these options are required to be introduced at the very first step, and I think that is the first semester. So these are some of the foundations which work there, and I think that has been followed in some other jurisdiction, and India is also one of the follower of that type of approach. Though the time you could say in between, if I say the Western jurisdiction and the Indian jurisdiction is comparatively much more, but it's never too late. That's why we have got the fruits also. Now, if I further proceed with the same one, then Newell Thomas Dowling and Edwin Velek Patterson and Richard Y. Powell, they have written a book which is known as Materials for Legal Method. And this book is considered as the very first book which has been written on this particular subject, published by the Foundation Press. So from here onwards, that academic discourse, discussion, deliberation started. And obviously now we are not giving that much a reference to this particular book. For us, the authority is, you could say, Sharon Hansen or different writers. But when we try to trace the origin, obviously we have to cite the year 1946. And as I said, legal method is a subject which introduces legal institutions, theories, and practices to the first year law students. And obviously, the field of the law is such a field which is not with some prerequisite. Like obviously, we are very much understand this fact that here those who have science background, those who are having the banking or the commerce background, or those who are from the arts background, they all are welcome to join the law courses. However, how they are going to pursue the law, this is something a very challenging task. So that's why until and unless the bridge has not been made in between 10 plus 2 courses or 10 plus 2 plus 3 towards the legal education, then overall duration which is going to be there, whether that could be of 3 years or whether that is going to be of 5 years, this itself is going to be very challenging. And as a matter of fact, the outcome of the complete legal education process, that too also is going to be very much challenging. That's why in the beginning year itself, there is a need to have such type of subject so that that bridge could be filled. Apart from that, when we talk about the importance of the legal method, then I could say that it is to create a defense mechanism against the harsh sink or swim approach, or which is also known as the Spartan method. What I mean to say sink or swim approach or the Spartan method, simply as we are aware that there are n number of subjects in the field of the law. And obviously those who are, you could say, imparting any specific subject as a honors paper or as an optional paper or as a compulsory paper, we could not expect from teacher or from the professor that they are going to inculcate a very basic skills to the students. Fine. They are not there to start with the beginning. Obviously, they are supposed to work with a presumption that if a student has reached to the second semester or the second year or in the fourth or the fifth year, whatever the case it may be, they have the basic understanding about the law, means how to read the law, how to apply the law. That's why, or what are the going to be the effects of the law. That's why they are primarily concerned with the knowledge impartation, in spite of the fact that in this process, sometimes they miss whether what they have tried to convey that has been received in a well manner or not. It's a different part of the story, and that's why legal method work as a defense, so that before such type of students, those who are very new in the field of the law, and where they are going to get together with such type of professors, which are there just to impart knowledge only, they are supposed to have the understanding about how to read the law and how to apply the law and what are going to be the effects of that particular law. And in that respect, if we take a reference of Professor Strong, what he has mentioned about the educative elements, he has mentioned that there are different, you could say, approaches which could be applied, like the informational one, theoretical one, doctrinal, transactional, applicational, valuational, functional. But more or less, the point is that when these all are required to be introduced to the first year students, so that as and when they are going to, you could say, encounter with any of the faculty who is following any specific type of approach to deal with the law, that student must be in a position at least to understand that type of subject. Because obviously, each and every subjects in the field of the law are different, and the approaches obviously of each and every faculty member is also going to be different. But in that respect, I think the student is required to have a broader understanding about different types of methods, because as and when any type of method is going to be applied, a student must be in a position to understand. That's why another, you could say, reference point which could make here is of the inventory of legal capacities, which has been cited by Professor Strong. And when he has cited about different inventories which are required to be there with the law student, he has given reference to the legal method also. So these are some of the very basic fundamentals when we talk about the legal methods. And apart from that one, I have highlighted three prime justification why it has been felt that there is a need to have a separate course, in fact, an independent course in the name of legal method. And now obviously we have. So first of all, in order to save time that is desperately needed for law school as a whole, as well as the teacher and the student. So as I mentioned, whether that particular institution is following the trimester system or is following the semester system or yearly system, in every, you could say, component, the time is not that much to start with the beginning. N number of subjects are there, N number of, you could say, elements in that subject which are required to be covered, or I could say uncovered. That's why it's very important to at least know the nuances, as I mentioned, to know about the law, to of the law, so that time could be saved of the institution, of the teachers, as well as the students. So that whatever the time which is going to be saved, that is going to be applied to know more about the subjects. Then to add skills and values to the already overloaded law school curriculum. And most important thing is to shift from the content focused programs of instructions to outcomes focused programs of instruction. Now, what I mean to say about by the outcomes focused programs of the instruction is simply that students have to understand that whatever the subject which they are going to study or which they are going to research, each and every subject in the field of the law has its own scope. What I mean to say that the scope is not only from just the criminal law or just from the corporate law, but whatever the subject which you are going to undertake, obviously there's enough scope in that particular subject. But only the condition which is required to be there is that how much you have understood. This is something which is required to be inculcated in the students. That's why by just imparting the content in the name of the legal education, I think that should be more outcome focused. Like for example, if I am delivering lecture in the field of international trade law, then apart from teaching the foreign trade policies or the import export regarding regulatory aspect, I think I have to mention that what are the things which are needed to be discussed so that a person could see a future prospect in that particular area. These types of approaches are required to be applied. And I think in this way, the legal method could be a foundation course. It doesn't claim, or you could say, rather, it could not be also as a course from the specialization perspective. But I think that would be a starting point. That's why in the first semester, this course is there. So, foundation of legal method, as I have discussed earlier, that the traditional teaching methods in the English universities, primarily in the Western countries, have been lectures and tutorials, which includes the seminars also. And that has followed more than centuries. In fact, right now, if I say in the England, and primarily if I try to differentiate England with the US legal education system, in England, that is still more inclined towards the lecture and the tutorial method. But the US, in fact, the last century, they are fully shifted more or less towards the case method. So the case method became the prevailing technique in the United States following the work of Christopher Columbus Langdell, as I mentioned, at the Harvard in the latter half of the 19th century. And obviously, this is something which has given them the extra, you could say, edge. That's why they have been highly successful. It's a different part of the story that when we talk about the lawyers there, then in the nation development, they have played crucial role. Apart from that one, if I talk about the overall evolution of the law, then obviously the statutory laws that has been started to design much late because the law has been evolved by the judges and there also the bar has played crucial role. That's why the case method was the need of the hour. That way, that has started there. However, in the continental European countries, the backbone of the legal education is still that is a formal lecture. And if you try to see the attendance, that is frequently voluntary. In Russia, as in Western Europe, the lecture method supplemented by smaller discussion groups and it's a typical form to impart education. In fact, I have not cited here the different modes of the evaluation. Otherwise, that was supposed to take much time. But in that field also, there are different settings which they have applied. It's not something like the rigorous mode to impart education and by just evaluating the students from the grading point of view. It's not something which you could say they are following. So modern legal education, however, in India began with the establishment of the Government Law College at the Bombay in 1855. And I have mentioned this thing, you could say intentionally, with the appointment of one professor of jurisprudence. That's why we try to see the current legal education rules where at the number one, the jurisprudence is mentioned. This is something which is in fact till the British time period. And the one professor of the jurisprudence, and in fact for further decades, the jurisprudence or that type of theoretical discussion deliberations have been major part of the legal education. The practical courses like the corporate or the business, in fact the taxation, you could say much time have been taken by the law schools in India as far as the introduction in fact is concerned in the field of legal education. So legal education in most places outside USA is concerned with transmitting information about legal conceptions and doctrines and by way of contract. American law schools are concerned with legal method instead of legal doctrines. And that is the main difference which I have tried to, you could say, put here. That's why much, you could say, authority, much respect have been enjoyed in the United States of America. If I talk about the legal profession or the legal education as a whole, in comparison to some other parts as we are discussing here. Reason the way they have understood the law, the way they have applied the law, this is something different because they have tried to see the law, they have tried to apply the law, not only just as a content perspective, but as a method perspective. So I think that was needed and that trend has started in India with a wave of globalization. In fact, before the wave of globalization, when this idea to have the integrated law courses or when the first NLU came into existence, then this thing which I am trying to convey here, that from content based to outcome based, that type of structure has started in India. And that's why two reports which I have mentioned here, one is Carnegie report and second one is the best practices for the legal education, which could say time and again have been cited by Professor Madhav Menon also. which are dealing with the advancement of teaching on educating lawyers, and Clinical Legal Education Association, which made this best practices for the legal education. There also this content to the outcome based have been discussed, deliberated. And these were some of the foundations on the basis of which this legal method as a subject has been introduced in 5-year course in a very first semester. So I think enough foundation which I have laid down in the name of legal method. Now I will shift towards the draft which is required to be followed. In fact, I have followed with the, you could say, consent of the authorities that I am going to discuss. So first of all, obviously, the law. What is the law, or the difference between a law, the law, and law, you could say, are required to be covered, like the meaning, nature, and the functions. So obviously, we are not supposed to, you could say, dump the students with the definitions. We have to discuss how the law itself has been evolved, because we have to understand that they have just came after clearing their 12th, or might be they are working somewhere, or they are doing some other courses, if I say from the 3-year courses point of view. That's why we have to provide them a safe, you could say, path to enter in the field of legal education. That's why we are not generally supposed to engage them with something which they have to remember. Rather, we have to engage them with something which is required to be understood. That's why we have to start with the evolution of the law. We have to discuss about the ancient India. We have to discuss about the Greek, Roman, Christian. I have mentioned ancient India first because this concept also, I think, has not been the dominant one in the field of legal education. And I feel sorry to say that the indigenous education system, or the indigenous, the meaning of the law, is something which is required to be given, at least in the Indian setting. Then we have to move towards the Greek, Roman, or the Christian. I think that will give them familiarity to understand the law. So in this way, we have to begin with the evolution. And obviously, in this process, we have to discuss about the study of the law from different approaches, which are generally known as the school of the law. So rather, you could say, cite it as a school, I prefer to cite as approaches. Because when we say school, then simply we are referring subject which is known as jurisprudence or legal theory. But here, the whole objective is not something to, you could say, impart any lecture in the name of jurisprudence or any session in the name of legal theory, but just to give them idea that it depends on the time, it depends on the place, and moreover, it depends on the requirement that which type of law is going to be evolved. That's why primarily the historical, or you could say the natural, or the analytical, or the sociological, different types of schools which are there, are required to be understood and are required to be imparted in the name of approaches. What I'm trying to convey here is that suppose before the positivism, that historical and sociological schools were there, which all of us are aware. But after the First World War and after the Second World War, primarily that the revival of natural laws started. Because when we talk about the natural law, it means we are talking about the universalism. There's some set of norms, some set of laws which are required to be applicable at the time of peace as well as at the time of war. So in that way, if you try to discuss, deliberate, then I think they will feel more connected with the law or the legal subjects which are there. So I think that would be a good starting point. Then the definition of the law that we have to discuss, and number of jurists and number of writers and number of institutions have given the definition of law which we could cite. But at the same point of time, we have to develop the critical thinking and the analytical thinking, for which we have to refer different documents. That's why in my classes, usually I used to cite this equation, which has been given by a professor who worked there in the University of Queensland, Professor Jerker. He has defined the law in the form of this equation, like L is equal to N within bracket LR plus LC. Here L stands from the law and means number of rules which are going to be applicable. LR means that specific type of rule, and plus LC means the context in which that particular law is going to be applicable. So in this way, we have to explain, or we have to connect the students with the field of the law. Then we have to discuss about the functions of the law. We have to discuss about the classification of law. See, classification of law is very important to be discussed at the first year in this course, because what we have seen, the current trend also, is that more and more, you could say, job opportunities are there in the field of new subjects. But when we talk about the new subjects, obviously, then the traditional pedagogy as well as the traditional approach to understand the law, that itself has been transformed. That's why until unless we will not, you could say, discuss, deliberate different subjects from different classification point of view, I think that would be difficult for the first year students to understand the law. Because what are the rules? Just this is the example point of view. What are the rules which are applicable in domestic jurisdiction or the national or the municipal jurisdiction are not something which are applicable in the case of international law. Might be from the national law point of view, sovereignty is the one of the finest principle which is required to be discussed at length. But when we talk from the international law point of view, we have to discuss about the compromise also of the sovereignty to give way to the international institution. So in that way, I think in spite to just deal with the theories or just to deal with the definition, we have to connect with the practical or the pragmatic aspects of the law. Then the last head which I used to discuss is law, justice, and the morality. Reason being, this is needed because to you could say develop a brain towards civic professionalism. Law is not something very dry subject. It is very organic in nature, and that's why the role which is going to be played by the law graduates, that should also not be dry one. That should also not be a mechanical one. It itself supposed to be evolutionary in nature, and more important, that is supposed to be towards society. So in that way, in this way, like we have to begin. Then sources of law, which we have to discuss, the meaning of sources of the law, primary and secondary sources that we have to discuss, deliberate. Then obviously we are aware with these different heads which I have mentioned, like the customs, then definitions, essentials, types, requisites of valid custom and binding force of custom, then precedent, definition, essentials and the types, then the doctrine of stare decisis. And while dealing with the stare decisis, you could say doctrine, we have to give more emphasis on the circumstances which destroy or weaken the binding force of the president. That also we have to connect with the recent cases or the recent controversy which is going on in the court of the law. So I think that would be more like the connecting point which we have to establish. Then legislation, definition, essential, types, subordinate, as well as the supreme legislation. And at the last, we have to do some comparative analysis in custom, precedent, and legislation. As we know, the ancient one is a custom and the recent one is a legislation. But when the custom is supposed to gain the prominence, in fact, in the modern society, and when legislation itself is supposed to give way to the custom, so these are the points which we have to, I think, discuss, deliberate in the name of sources of the law. Then fundamentals of statutory interpretation. There is also one of the important, you could say, module that we have to introduce. Because what I have felt in is that in some of the, in fact, national law universities also I am citing here, and correct me if I'm wrong, that in fact interpretation of statutes, which is so much important, that is not there as a subject, which is a mandatory subject in 3-year course. That's why those who are willing to be a lawyer or those who are going to serve a nation as a judge without understanding of the interpretation of statutes, I think it's going to be a challenging task. That's why obviously teachers are not going to have that authority to introduce a subject, but at least in a subject they could introduce a module just to give a basic understanding. From that point of view, some of the fundamentals of statutory interpretation that could be discussed, like what are the stages in the preparation of statutes. And when I discuss these stages in the preparation of statutes, I could cite Indian scenario also. In fact, there was a time, and I could cite here also, 1989 is a year when Institute of Legislative Drafting and Research, ILDR, came into picture. When we try to see why this institution came into picture, we could easily understand because n number of new laws were going to be drafted. And that's why much research, discussion, deliberation was required to be there. Fine, that is one part of the story when we talk about the institutes. In a similar way, when we talk about the stages, these are required to be discussed, deliberated, so that a student could connect about the growth and the development of the law and the understanding of the black and white law and the application of the same. So elements of the statutory law and their use in understanding and interpreting institutes, that would be the part of the discussion. Classification of institutes, we have to understand. There are some on the basis of the objectives. There are some on the basis of the time and the longevity. These are required to be discussed. Then there's a ancient act which is still applicable and which is mostly referred when any specific definition has not been given in any specific institute, or if there's a doubt with respect to the definition which is given in any specific institute, then we refer General Clauses Act. So we have to discuss about the importance of the same. Then we have to shift towards different rules of the interpretations, maxims and the presumptions in interpretation of the statutory law. Then primarily we have to discuss about the liberal rule, literal rule, golden rule, mischief rule, and then we have to shift focus towards the eight to interpretation of statutes, which are primarily the internal and the external, and which I have mentioned here also, which are known as text of the law and text about the law. So text of the law means what's about you could say of the law means the statute or the codification, and text about the law means the elements what are there. So in that way, we have to deal with the interpretation of statutes. Then we have to shift towards the judicial process. And I think we have to give much time on this particular module because this is something which is important from the development of cognitive thinking or the analytical skill. So that we have to start from the concept and the nature of judicial process. We have to discuss this particular topic from, you could say, judge made, you could say, law point of view. Like we have to discuss about the role of a judge, whether they are just the interpreter of the law or they are also the makers of the law. We also discuss what are the factors which are applicable whenever any judgment is going to be pronounced. Whether the education, whether the upbringing of a judge is also something which is supposed to play the role. Fine. So all these types of things are also required to be discussed. Then only students are supposed to connect with the overall judicial system or the legal system. We have to discuss about the necessity and the application of case law method in the study of the law. We have to give more emphasis. That's not something that which has been settled once that could not be changed. Or we have to discuss about the factors which play a crucial role towards the setting of the law also in the name of the president through various examples that we could discuss. We have to discuss about the parts of judgment which we are aware are known as ratio decidendi and the opta dicta, and we have to see what are the you could say tests to find out the ratio decidendi of the case, like Professor Van Vogt, Professor Goodhart. There are theories like the reversal theory, abstract theory, material fact theory. These are required to be discussed when we discuss about ratio decidendi. We have to discuss about the majority and the minority opinions, how much role you could say these different opinions play toward the development of the law. We have to discuss about the importance of dissent. In fact, this is also one of the most important point which we have to highlight, that might be that dissenting opinion at that point of time when that has been given has not well received neither by the bench nor by the nation, but sometimes which we have seen that has played crucial role towards the change in the law itself. So dissent is also one of the very important point which is required to be discussed, deliberated, because it gives critical thinking, and critical thinking is something which is the base of the development of the law. Then we have to discuss about the decisions reached per incurium, decisions reached in sub silentio. I think discussing about these types of different elements will give a student of the first year understanding that how to read a judgment, how to read a decision, how to read a case, what are the different heads of the case. And this is important because by just you could say reading what is already written in the books, or by just you could say delivering the lecture with the help of some notes which have been prepared at some given point of time, that would be some you could say incomplete type of framework. So to give it you could say finality, or at least to make it more and more comprehensive, I think we have to inculcate the habit how to deal with the case. How to deal with the case means how to deal with different contents which are there in the name of case or a judgment. So that's why much more you could say emphasis is required to be given on the practicality of the cases or the judgments. And for that reason, the last point which I mentioned in the syllabus is inductive reasoning, analogical reasoning, deductive reasoning, probability, causation in legal reasoning. These are some of the elements which are required to be used in this particular module. Then the basic concepts of the Indian legal system, we have to give more emphasis on this one because you could say, after this, like after the first year or the first semester, I don't think that they are going to engage with legal system as a whole. That is not something as an independent subject. So that's why that understanding is also required to be, you could say, developed in the first year itself. So the concept of the rule of law, like the general introduction, what does it mean by rule of law, meaning and historical background. And here we do not have to limit ourselves only with the AV Dicey or any specific, you could say, writer, but we have to see different approaches, different philosophies which have been applied in the name of rule of law. So primarily the supremacy of the law, equality before the law, and the judge-made constitution. That would be the part of discussion. And apart from theory, we have to discuss about the application, merit, pitfalls of the doctrine, and we have to discuss about the modern concept of the rule of law. Like here, I could give an example that rule of law is not only just as a part of a theory which is governed in the administrative law, but in fact, this itself is a project which is known as World Justice Project. Fine, which is funded by the World Bank, which deals with the rule of law index. So rule of law index, basically, if you talk, there are different parameters on the basis of which countries are generally ranked. Like there's a parameter with respect to the governance, there's a parameter with respect to the transparency, accountability, there's a parameter with respect to the civil justice system, there's a parameter with respect to the criminal justice system. That's why when we talk in this respect, like what is the importance of a rule of law from practicality point of view, then I think that would be more interesting in the first year itself, and they will try to search more and more how the theories are important from practical point of view. In a similar way, doctrine of separation of powers, we have to discuss about the same in a general manner, introductory point of view, then meaning and historical background, then effects, defects, importance, and the practice. Then one of the most important thing that we have to include in this module is about the judicial review, the nature and the scope. Because I think this is something which has set the path for a nation development. Fine, that any law should not be, you could say, accepted as such in all the given situations, in all the given circumstances. But whenever there is a need to change, or whether there is a need to at least review the same, so that just to check whether it still it holds value or it is relevant, I think we have to deal with the judicial review. Then we have to discuss about judicial activism, the origin of the same, evolution, and the impact, and some of the very important judgments with respect to different areas like the environment, human rights, consumer, etc., are required to be covered. Just I hope I am audible.
Yes, yes, you are audible.
So the last module which we have to include in this subject is legal writing and legal research. And I think this is a differentiating point in between the 3-year course and 5-year course. Because in 3-year courses, as per my understanding or my limited knowledge, there is no subject, in fact, in the name of research methodology. Kalpeshji, you can correct me if I'm wrong.
Yes, yes, yes. There is no subject. So that's why we call sometimes legal method research, LMR. This
Correct,
subject,
correct.
yeah.
So some of the universities, in fact, the graduates even they are not aware how to write a paper. If I say about 3-year course, and it's the biggest limitation. But in the case of first year, this one 5-year courses in the very first semester, in fact, in the legal method, in a one module or two modules, that could be depend on the time and depend on the other engagements of the faculty with respect to different topics. This is something which is very much common, whether the course is BA LLB or BCom LLB or BSc LLB. That is some understanding with respect to the legal writing and legal research could be developed to the first year students. See, it has twofold objectives which we consider is first of all to develop the interest in the first year students so that they could read more to write more, which is something supposed to be authentic one. Second thing is to develop this understanding in the students of the first year students that by just copying and pasting will not suffice the purpose. It has its own legal as well as ethical complications. So how to address these things without giving them the knowledge about these things? I think it would be very unjust on their part to expect to follow originality. That's why the first year in the legal method, we used to discuss deliberate in the name of legal writings and legal research. So first of all, we have to discuss for the meaning of research. We have to discuss for the difference between research in general and the legal research in specific. Then importance of legal research, importance also from different stakeholders' point of view, like what is the importance for student, what is the importance for teacher, what is the importance for you could say lawyers or attorneys or law clerks or judges, in fact, or the policymakers. So in that way, it will help them to understand so that they could also engage in the process of research. Then we have to discuss about the techniques and types. We have to discuss about the primary and secondary sources of the legal research. And we have to discuss, though a number of types are there, but primarily we have to focus with first year students in the field of doctrinal and non-doctrinal, which is also known as empirical and methods of data collection. And at last, we have to deal with some practicality, like what are the modes to cite the sources, the meaning and importance of citation, and different modes of citations could be applied, but generally 21st edition of the Blue Book, which we use to cite, and from indigenous point of view, that ILI, these two are the must, which are required to be discussed, deliberated in the class. So in this way, total 6 modules, which could be a good starting point in the name of legal method, and that will help first year students to at least feel comfortable with respect to the overall legal education atmosphere, which is not a very short duration. It's of half decade or minimum that is of 3 years. So until unless some foundation which has not been laid, they will not feel connected. So in this way, we have to design. Obviously, changes could be there in this draft syllabus, subject to the approval of the authorities or the autonomy which is given. But more or less, that would be the framework for the first year students. Then some suggested pedagogy and the teaching method, which we can take a look. And for that one, I have mentioned about one article which has been written by Gary A. Munique with the title Legal Skills for a Transforming Profession. What he has mentioned in this article is that legal profession is influenced by societal changes and legal education must be re-engineered to accommodate these changes and to prepare students for the contemporary professional world they will enter. Now, when I read this statement, which has been mentioned by Professor Munique, then it gives us idea that might be at the given point of time when we were a student, teaching method which has been adopted by the respective faculty was something different. When we have started to teach in our first year, at that point of time, might be we are using some different method. But we have to understand that depends on the need, requirement, and the changes. We have to revisit in the method which we are following. We have to revisit the pedagogy which we are following. And this is something which I am telling for a subject as a whole. And that too also I am telling with respect to the specific components of the subjects. And keeping that thing in mind, there are different methods could be applied in this legal method subject. So one method which has been, you could say, there centuries back, in fact, which is still there, is known as lecture method. However, a little bit difference which could make in the lecture method by the use of modern technology. And the COVID era has given us that particular understanding how to use technology in a more better manner. So that's why we could say with the help of multimedia technology, we can make lecture method also more interesting. Obviously, it has its own limitation, which has been, you could say, identified by some of the critic, like it is monotonous, it is a one-way communication. But at the same point of time, we could not ignore the importance also of this lecture method, because this is the only method which helps at least to establish some foundation, which is important to be established for the complete batch or the complete section to which we are going to impart the education, at least that particular subject. So that's why lecture method is one of the prime method which we have to follow. Then obviously the case study method, which I have cited earlier, like it should be the participatory one. It's not only that the teacher is supposed to impart, but students are also supposed to be prepared with the cases, and in that way it's something which is supposed to be participatory, as I said, that both teacher as well as the student are supposed to discuss, deliberate about the law with the help of that specific case. And case study has been identified, obviously, that is most useful to improve the critical cognitive thinking in the students, because through this only they could understand how to apply the law. So that's why what is law, that could be there with the lecture method, but how to apply the law, this is something with the help of case study method. Then case law analysis method, it gives us idea that whenever we read any judgment, whenever we read any case, might be key terms point of view, there are some subjects. But when we try to apply different elements of that particular judgment, it is quite possible that different other fields or the different other areas of interest are going to be connected. Might be at present, might be in a future point of view, we could understand that that could be the future, like the cascading effect of this one. From that perspective, we could understand the case law analysis method. So case law analysis could be from merit and the demerit point of view, that could be appreciation or the criticism point of view. These are some parts. Then we can use a group discussion method. We can give any specific topic which is going to be discussed, deliberated. We can give our input in that one. That's why is known as the debate method also. We can use audio visual methods. We can use diagram method. Like yesterday, I've seen Kalpesh has posted one, you could say, chart. I think if I'm not wrong, that was connected with the contract law. This is also one of the highly appreciated method in the field of, you could say, teaching law primarily. In fact, the Sharon Hansen, who is the authority also of this subject, in his book, he has discussed how to teach law with the help of different charts. Like so much complexity is there in the field of the law. In fact, when we read any judgment, but if we try to transform the same with the help of any specific chart, that is going to be there in our mind, because we are pretty much aware that something which is there in the image, uh, that is going to retain in the mind for a much longer time. So I think visualization, which is known as, that is something which could help us to understand the law and to apply the law also, because that is going to be there in the mind. And for that example, I have cited here, like when we discuss about the separation of powers, primarily with the help of three circles, we can discuss. One denotes legislature and executive and judiciary, which is something supposed to be there if the separation of powers works in its finality, but it doesn't happen. In the democratic societies, these three circles are supposed to intersect. Like the legislature is supposed to intersect with the executive, and the judiciary is supposed to intersect with the executive. So in that way, what would be the intersection point, or by which name or by which concept these intersections would be known? So in that way, we could discuss that when the legislature is going to be intersect with the executive, then that would be the case of quasi, you could say, judicial, quasi legislation, which is known as, you could say, delegated legislation in a common understanding, which is known as delegated legislation. But when we talk about the intersection of the executive and judiciary, that is known as quasi judicial, means which is known as the tribunalization, the concept of tribunal which came into picture. So in that way, when we'll use some table, when we'll use some chart or Venn diagrams, I think that will create more interest, and that is going to be there in the mind for more and more, you could say, longer time period. Then one of the method which has been introduced in the field of the law is collaborative teaching method. That those who are experts in this particular field, they could join, you could say, to impart any specific topic in the course. So I think that would help to make more and more interesting any specific subject, any specific topic. And apart from all these methods which I have cited, we have to focus on the skill training in the field of legal research and writing. So for that one, obviously, weekly basis, or you could say fortnightly or monthly, we have to go ahead with some workshops. And that I'm not saying from national or international, but I'm saying only from class perspective. That would be in between student and teacher. That we have to give some assignments. We have to ask them to write. We have to ask them to research. And in that way, I think if these different methods or different pedagogies have been applied, we can make subjects more interesting and more demanding and more useful, most of all, for the students. The last one is evaluation and assessment of course. There are different ways which could be adopted. In my university, this is something which we are following. Continuous internal assessment, which is of 25 marks, then midterm is of 25 and term is of 15. So overall 100 marks. And CIA, which is known as continuous internal assessment, is the components of internal assessment, which I have just cited in my previous slide. It's something which is required to be designed to promote the cognitive ability, analytical skill, creativity, and subject understanding of the students. So that's why different components which could be applied, which could be given by the faculty, and different, in fact, guidelines could be made by the faculty members for the evaluation of the components which are there in the name of continuous internal assessments. So these are different heads which could be given, like the case law analysis could be given to the students, book review, class presentation, assignment, simulation game, documentary review, short film making, mood court, etc. So these are some, just from the identification point of view, it's not something a complete list, but in this way we could engage, you could say, student throughout the semester, and that's why they are supposed to just come out of the burden of the midterm and the end term, because continuously they are going to be engaged in a learning process. However, after having discussion on all these points, I have to highlight some issues and challenges in the implementation. And the biggest, you could say, challenge that I will begin with the words of John Locke, what he has mentioned, is that the law student is not quite the tabula rasa, but a neophyte as well. And I think on this point, we all, you could say, must be agree that this is more applicable when a student is there in the first semester. From different backgrounds they are coming, from different understanding which they have, and most importantly, that would be the case that they are going to have a preconceived understanding of any specific subject. That's why the task for the teacher who is going to, you could say, engage with the first year student is little bit more complicated. That how a blank, you could say, slate is going to be filled, or something is written there, how that could be corrected. This is the biggest challenge as far as the subject legal method is concerned. Then to construct a bridge between a school to university, as I mentioned in the opening statement, as there is no concept like the uniform pre-legal program or the education that exists universally in the field of legal education. So time and again, I think some conceptualization has been made in the name of Master of Legal Education. But I think this is something which doesn't exist in Indian domain. And I'm subject to correction what I'm saying. So in this regard, obviously, it's going to be more challenging for a teacher to know how to teach, especially to the first year student. And that's why it's not something that by just clearing UGC NET or any specific type of examination, that type of approach is going to be developed until someone is there to guide, or if a self-learning process is going to be applied. This is something which is going to be a challenge, how to deal with the novice in the field of the law. So this is something, how to construct a bridge, then to thoroughly examine the capricious character of inquiries posed by first year law students throughout a 1 hour or might be 45 or 2 hours legal method discussion. Like obviously you could not stop, or any teacher could not stop a question or series of questions which are going to be asked. But the timing of the questions, character and the nature of the question is something which is going to be very challenging for a teacher who is there in the first year. Sometimes a teacher could feel comfortable. Sometimes a teacher is itself supposed to think whether it's a genuine concern or a student is just asking out of curiosity or just to prove something. These are something which are required to be get addressed. Then to develop an understanding of the diversity of the class from an academic discourse point of view. This I have mentioned because if you read some of the reports like the Elusive Island of Excellence, a study on the student demographies, accessibility and inclusivity at national law schools, or if we read Increasing Diversity by Increasing Access, that diversity survey report or different reports, it is quite clear that each and every student in any class is not equal as far as academic understanding is concerned. In a similar way, they are not equal in terms of the subject understanding, because someone is there from science, as I mentioned, someone is there from the art, someone is there from the commerce. The same point of time, they're also not equal from the socio-economical point of view. That's why what a teacher who is going to discuss, deliberate with the first year student, how that teacher is going to frame sentence, how that particular teacher is going to give the example, which is going to be well received by all, like from the hedonistic calculator point of view, hedonism point of view. This itself is a very challenging. That's why it takes time, in fact, to actually get a grip how to engage with the students, especially all the first year students. So these are those some limitations. However, we can come over all these types of issues and the challenges. But obviously, that much time, that much understanding, that much self evolution and the self learning is also needed on the part of teacher. On that note, what Sharon Hansen has mentioned, and I will conclude my presentation, is that legal study and intellectual discipline come with a cost, and it is an often struggle to reach a place of understanding. However, to demonstrate a good level of competency in legal study is within the grasp of everyone. That's why what would be the method, what would be the subject, what would be the content, how to deal with the students, whether in the first year or final year. This is not something a trade secret anymore. With the you could say impact of globalization, we are in a pretty much comfortable position to access resources, and we can learn, we can read, revise, resynthesize, and we can apply the same in our class. So there are some, you could say, lists which I have mentioned in the name of books. The authority in this field is Sharon Hansen. Then jurisprudence for different, you could say, constitution. Depends on the area which we are going to cover in this particular subject. We can refer the books. So I have highlighted some books. Due to paucity of time, I'm not going to, you could say, explain the relevance of different books or the reading materials which I have cited here. But this is something which are must when we are referring the legal method. So I have cited some articles also, because obviously articles are having some more advantage in one sense, that it reflects analytical, you could say, ability of a writer. It's not something from description point of view. So that's why reading article gives more, you could say, idea about that concept from cognitive thinking perspective. And these are some of the important books and the readings apart from this course, and they are must for the first year students, like the Learning the Law, Granville Williams, the concept of the law, actually Hart. In the case of judgments, obviously the Zia Modi has written about 10 judgments that change India. There's some of the very important, you could say, points which I have to make to our first year students. And I will end my session with the words of John Dewey, that the idea of education is the idea of continuous reconstruction of experience. So I am thankful to Kalpesh for giving the opportunity to discuss, deliberate, and this is something very much, you could say, applicable for all of us, because might be when we are going to teach any course at a first point, our own understanding with that subject is going to be different, and when we are going to teach that subject after 5 years, after 10 years, there is going to be something different. So in fact, the teaching method, teaching pedagogy, or or you could say all the aspects of the legal education or education for that matter, that comes with experience. So what I have in my own, you could say, limited capacity, I try to put before all of you, and I'm subject to correction and improvisation. Thank you all.
Thank you very much, Dr. Ankit. At the outset, let me tell you, like, this is the most important subject, I would say, in the law schools, because obviously integrated course, and the most neglected one. Like, if please correct me if I'm not wrong. Generally, what happens, like in the subject allocation, young faculty, you take, this course, not, and actually it should be taught by the senior ones, because, laying the foundation stones for the students, and that I have seen it's really in a bad stage, because this is my experience. I have seen various point of time, and it's good. Let me take up the second questions. Participant, you can raise your hand. I will unmute you, or you can put the question in the chat box. There's a big question, the lined up by Kanchan. So one question suggests some good readings, both articles and books on the subject. That's already done. Some landmark cases highlighting obiter dicta part of the judgments. So again, you can obviously share later on. The
I will
third
share.
one,
I will share the PPT. That could be shared with all.
course,
I think
definitely.
that will come from fair use point of view.
Yeah, yeah, definitely. And I can see you have put up a lot of efforts in putting structure. I would say the most structured PPT till date. Today is the 24th day of fourth week is going on. Most structured PPT that you have prepared, that probably uh, uh,
Thank.
some good videos to be shown for the understanding of legal method on any of the topics explained by you. And then yeah, can you please reiterate the formula for explaining the definition of law? It was intriguing. So that is a question.
I'm writing here in the chat option, and I will share the PPT also. No issue.
Okay, yeah. So there is a question from Anil Nair. Ideally, shouldn't we be teaching this subject in later semester than in the initial semester? So, what's your take on this?
Yes, pardon. Please repeat.
This question from Anil Nair. Ideally, shouldn't we be teaching this subject in later semester than the initial semester?
See, as I have mentioned that the legal method as an independent subject, if you see the origin of the subject, uh, then the exact positioning is the first year itself, first semester itself. But obviously, as you have mentioned, that the autonomy which has been given to the board of studies or different authorities that works at the university level, that depends at what position that they are going to fix. Because this is something which has not been prescribed by our regulator, which everyone aware, Bar Council of India. That is something which is very much clear in the 3 year course. In a first year, which course, second year, which course, 3 year, which course. But in integrated course, they have given us a plan, and depends on the subject, you could say allotment which you have mentioned. At the same point of time, availability of the faculty member, it depends at what positioning that particular subject is going to place. I was sitting on that record, and I came to know that in India, though we offer like the optional courses around 40-50 in good NLUs, that is much lesser. If I say in some other, you could say colleges, that is 10 or 20. And I was surprised that in Western countries, this number of optional paper is more than 300. More than 300. The number of optional papers. Why so? Because they are living in an era of super specialization. For us, IPR. But now they are working in the field of fashion industry. So what would be the more important areas with respect to the fashion law from IPR perspective? That would be the part in the optional paper. For me, if suppose if I am teaching the international trade law, I will take that one as a subject. But in Western countries, they are discussing about Article number 20 of General Agreement on Tariffs and Trade, their clause G. What is the applicability of clause G from EU regulation? It's connected with the environment. So in that way, until unless we will not understand the differences in the field of the law, I think to gain, you could say, edge is something which is going to be difficult. That's why again, I'm sorry to say that in terms of the number of advocates which are there, we are competing with the universities of America. But in terms of the contribution, we are far behind. It will take, you could say, decades, in fact, to come with them. And obviously, we have to begin with the education. So I'm not saying that we are going to change or we are going to be the trailblazer from the reform point of view. But at least what is there in our hand, we have to start with the same one. So whether we are going to teach in a first or final, we have to justify our positioning there.
Definitely. And then obviously we already seen, it takes, at least more than a decade, 10, 15 years, whatever subject they started, and then we adopt
Correct,
those
correct.
kind of things. That is a practice, I would say, in every field, not
True.
law. It takes 10, 15 years. There's a Asutosh, what do you would like to say something? Asutosh,
Thanks,
over to
Aras,
you.
of all for such a wonderful and informative session. Sir, I have a question. Uh,
Asutosh, sorry, there is an
this
internet connection from your side.
subject
Asutosh, uh, Asutosh,
I
can you
can you
drop
can
your
write.
this subject, one of those, just a second, sir. This subject is one of sessions, I mean, where there is entanglement of at least 4 different subjects. Sir, now, is it audible, sir? I think there is a end, sir. I'm not able. Sir, is it?
Yes, please repeat your question. If you're not able to speak, you can drop the question in the chat box. Please try it now. By that time, there's a input, I would say, remark from one of the faculties. So we have interpreted iOS in, the compulsory paper in Mumbai University.
Yes.
Obviously, in 3 year already, most of the, they have studied in iOS, and at most probably in the mid of the, third year of the
Yes.
5 year, or maybe in second year of the 3 year courses.
Correct.
And then I remember you talked about judicial process that I studied. There's a separate paper in when I did law,
Separate paper. Yes.
iOS and judicial process, and then there's a subject called, so different. Obviously, it's changed a lot, I would say, by the time. Asutosh, are you there? I definitely agree with iOS. How to read law.
True.
It should not be the later part of studying after so many papers and you're studying iOS in the later part. It should be in the first year itself. How to read law.
Correct. In the first
What
year.
is law, nature of law, sources of law, and this kind of thing should be in the first year, first semester. One second, Asutosh.
And on that note, I am saying when I have entered in the field of academics, and at that point of time, some of my colleagues, in fact, my LLM and PhD also from NLU, but in some of the colleges, they were having so much fear with one word that is known as Turnitin. I hope all of you are aware with this term, Turnitin. Turnitin. So I was curious why so much fear is there with this word Turnitin. Then I came to know they have not even visited the homepage of the Turnitin. Fine, which says to facilitate the research. The purpose of the Turnitin is not to, you could say, identify individual and put them behind the bar. The purpose of the Turnitin, how to make research more and more interesting and more authoritative by giving credit to those who have actually worked for the same. Fine. Like suppose if I say I have mentioned this particular equation, I will be wrong. That's why I have cited. This is Professor Jerker from the University of Queensland who has mentioned. So in that way, when we write any paper, we have to mention. But point is that one, if they have not been told, if they have not been educated, how to, you could say, cite the footnote, how to give references, obviously, like the consequences are going to be there, which we could not avoid. That's why few things, as we have mentioned, judicial process or iOS, these are independent subjects. In fact, judicial process is a subject in the LLM. But point is that one, like how to understand the law, when any judgment is going to be given there, it's not always just the fact and the law, but circumstances also work. I'm not saying from the media trial point of view. Circumstances, I am saying what the contemporary exponentio which is going to be applied. Like before globalization, the creation of the monopoly was itself wrong because MRTP Act was there, Monopolies Restrictive Taxes Act. But after 1991, with the wake of globalization, we have changed the concept. The law itself changed the concept. And having dominant position is not wrong. But to abuse the dominant position, this is something wrong. So until unless we will not understand the change, the shift in the approach of the law itself, we are not going to justify our role as a teacher. So I think in the beginning, we have to deal with all these areas.
Definitely. Yeah, thank you very much. Asutosh, are you there? If you are there, you can put your question forward. Couple of questions we can take up before we wind up. There's another, multidisciplinary approach in in the first year teaching, discussing those things, multidisciplinary approach. And second thing, sir, can you suggest an easiest ways to make a first year student to identify in a lengthy judgment like the obiter, dictum, and the ratio decidendi? So 2 questions, then we'll wind up. Yeah, over to you.
So multidisciplinary approach, basically, obviously, this is a well celebrated approach in current time because we understand this fact that law or for that matter any of the subject in its isolation that could not work. In fact, I could connect this thing from the international law or the international institutions point of view. After Second World War, the institutions which came into picture, they were having a specific objective. Like the IMF was having a specific objective, World Bank was having something specific objective, WTO, like ITO at that point of time, was having some specific objective. But when we see from the current sustainable development goals point of view, they all are required to work together. Soon as coherence, they are required to be coordinate, the coherent approach which is required to be applied. If we try to see why, then obviously we have to put the people at the top. That they do not have to see only from the finance point of view or monetary point of view or the exchanges point of view. But at the end of the day, how that is going to be, you could say, useful for the individual, like the people. In that way, when we talk about the multidisciplinary approach, then our approach is obviously that whenever we are going to take any specific topic, we have to try to apply different angles with respect to that particular topic. And that we can begin by questioning the same one. What I'm trying to convey is one very renowned, you could say, philosopher whose name is Descartes. He has mentioned that when we have to know something, we have to doubt that thing. We have to doubt. We do not have to receive as such. Like if any definition has been given by anyone, obviously we have to respect. But the point is that one, why we are going to accept the same one as such now? Might be that has been given centuries back. But what is the relevance of that definition right now? And what is the relevance of that one, not only from teacher's perspective, but what is the relevance of the same definition or same concept for a student? That would be the part of the discussion deliberation. That's why it should not be only from law point of view, that should be the social relevance point of view. In fact, from multidisciplinary point of view, I am citing this thing that we try to see the reforms which took place in the field of the law. Then the first reform was there from 1947 till the inception of BCI, which is known as the reform from professionalization point of view. Fine. There was a need to understand the law as a separate branch of the study because that is something by which a professionals are going to come and they are going to serve the legal system. So that was professionalism point of view. Second reform with the inception of BCI from standard setting point of view. Standard setting. Third one is from you could say practicality point of view because globalization was there. Then we have started to think from social relevance point of view. What is social relevance? When we are going to reduce the investment subject or trade subject or the completion subject, that was needed. That's why that has been introduced. Otherwise, before 1988, these subjects were never defined, never got placed in any of the curriculum or any of the rules of the legal education. So social relevance, what the need of the social relevance from law point of view. But right now in the era in which we are living is knowledge based one. And that too also education not from the domestic point of view but global point of view. That's why what we are going to discuss, deliberate, is not something only concentrated only with the area which we are going to focus, but it is going to have its own effect with other subject at domestic level, at international level. So until unless we will not develop that type of, like suppose I have given the example of rule of law. I could summarize rule of law by giving just David IC. Correct. I can summarize what Edward Vincent Dicey has mentioned centuries back. I can read, revise, resynthesize David IC again and again for 10 years. But until and unless I will not see what the pragmatic aspect of rule of law, like until unless I will not see how rule of law itself is a base to trust a country, because this is something on the basis of which rule of law index is there. And rule of law index talks about different parameters, which itself is a project of World Justice Project by that name, by the World Bank. Then I think we are not going to, you could say, even understand the multidisciplinary approach, and we are not going to apply that multidisciplinary approach in our teaching. So I think by the time, by the experience, and more importantly, by applying the cognitive thinking and the critical ability, first of all, with us, we are not going to apply the multidisciplinary approach in the class. So by practice, I think so. There is no shortcut which I can suggest. By more practice, we can.
So thank you very much, Dr. Ankit. Sorry, participant, we won't be able to take much more question, and I can see more questions related to this. The formulas become like E equal to MC square. That can I can see that buzz is there. I already shared. You just go through it, Google, and just what that formula talks
Correct.
about.
You can find out that article which I have mentioned is written by Professor Zerker from University of Queensland. In fact, I will forward the same to Kalpesh ji. Kalpesh ji can forward to all. It's not something which I have given, which I am saying here. But this is something which that professor has mentioned, and one of the article which I read, I think quite a decade back, I got that one. And I really admire that one because those who are from the maths background, they feel so happy when I cite this equation. Getting? So there was a time when law was by chance. Now the law is by choice. In fact, I have seen various, you could say, students, those who have got 100 out of 100 in their science and social science, and they are carrying the law education, legal education. Now, if we are going to be monotonous, if we are going to just follow the one-way communication, they are going to feel bored. And once they are going to feel bored, then obviously it's going to be reflected in class, in university, in school. How to manage all these things? I think the starting point would be class itself. If the class is maintained, if the discipline is maintained, via education, via teaching, rest things are the byproduct. I do personally think. So I will share the same.
Sure. Thank you very much. Kanchan, I think you should just send me those queries. I'll definitely forward to Dr. Ankit and you can, obviously I will share the detail. And thank
Yes.
you very much on behalf of our organization committee. I would like to thank you. And this, I would say, let me reiterate again, repeat. This is the most exhaustive presentation done by faculty till date. This is the 4th week, 24th like sessions, and you put a lot of effort in prepare this thing. This is very crucial. Let me tell you, I have not got the opportunity to teach this in first year. I don't get in first year, second year, third year. But again, if I, any faculty, they get the chance, go and teach this subject. At least, and then I have already jotted down some points, especially like in a collaborative teaching method. We can plan, okay, 2, 3 faculty, okay, teach this module. So that will be the more fruitful, I can say, feasible thing.
True.
Yeah. So thank you very much. Look forward to seeing future events also. Thank you very much.
My pleasure.
Thank you.
Thank you. Good night. Thank you.